Hello?
Hello, is that Mr. Sian?
It is, yes, hi Sean.
Hello, I'm really sorry for calling you a little bit later than scheduled. I was stuck on another call, unfortunately, but is it still a good time to speak?
Yes, it is, yes.
Okay, fantastic. Thank you very much. So before we go into any details, we'll go through the security processes, etc. So just confirm your full name for me.
It's Mr. Sajjad Hussain.
Thank you. The solicitors that the complaint's against.
Burke Niazi Solicitors.
Thank you. And your telephone number.
07404684743.
Thank you very much. And as you're aware, our calls are recorded, but mainly for feedback and quality purposes, okay?
Feedback and quality purposes, okay. And did you find out how long they recorded for?
Yes, I did. The team has come back to me. So they've advised that we keep call recordings for up to 6 years.
Oh, okay, that's good. Okay, all right.
Yeah, so that I think that is a staple part of the data protection laws, etc. So yeah, we keep call recordings for up to 6 years time, and obviously, this case will be dealt with by then. So by the time you do make a data protection request,
Yep.
you know, there'll be a record. Obviously, all our communications are the same as well, emails, etc.
Okay, that's fine.
So just to call you back really to say, obviously, follow on from our conversation last Thursday. Now, in terms of, there's two things I want to discuss really. So in terms of the evidence we discussed, obviously you supplied me a link to that YouTube channel and advised that your evidence was the audio recordings that you had saved on there. So it's just to come back to that point to say that's not suitable for us to use as evidence. So what we would request is, if anybody wants to submit audio recordings, which is, absolutely a valid piece of evidence, we'd ask that you supply it in MP3 format and that you timestamp the time of the call. For example, you could have had an hour call with the solicitor about something, but actually only 10 minutes of it is discussing the actual issue of the complaint that you've brought to us. So that's how we would request the evidence to come to us.
Well, I mean, the thing is that just to make you aware, Sean. I mean, like, the reality is that I've provided you with all the evidence. Now, you went away, and one of the things that you were going to do was you were going to discuss that with the Ombudsman regarding my submission of evidence. I mean, this is the evidence is available. So, can I ask if you've made a policy regarding this? Is it written down somewhere?
Yeah, correct. I did put a request in just to double check on our procedures to say, that was my understanding. The Ombudsman's come back to confirm that is our procedure. That's how we would accept evidence to come into us. So in terms of that, yeah, I'm happy that I've correctly advised on that procedure. And I know another question was, well, you asked us as well, if you did provide evidence to us, could we withhold that from the service provider? You didn't want them to see that in case you were to take it to court and you feel that they would have an unfair advantage by having sight of that now. We wouldn't withhold any evidence from complainants or service providers. We treat them the same way. So we wouldn't hold the evidence back unless there's a serious concern of anything that could be damaging or upsetting or very personal. From what you said, that you said that you don't want them to see it in case they get a heads up in future court proceedings, perhaps. So that isn't.
Sorry, go ahead.
No, so from what you said, so we would share everybody's information. So like I said, we treat it fairly. So whatever the service provider shares with us, so Burke Niazi, we would share that with you, and we would share your evidence with them. Whatever evidence it is that we use to our decision. So, for example, you could provide me, hours of phone call, but if actually only one of them relates to your complaint, I'll only share that 1 hour. If I refer to it in my case decision.
Well, okay. I mean, like, the thing is, the problem here is this, Sean. I mean, like, we've now got 20 complaints with the solicitors firm, yes, and they have turned around and said, "No, we don't accept any of them." All right. So they have said that they don't accept any of the complaints that I've lodged, and so that's 20 complaints. Now, the approach that you're taking is that, now I understand that, for example, if there was a case with a solicitor's firm, hypothetically speaking, and the case had run for, like, let's say, you say several years, hypothetically speaking. And throughout that time period, I was the complaint brought to yourself was, well, the service was fine except for this one little bit of information, little bit that I have a concern about. And and then therefore I think it would be unreasonable of yourselves under those circumstances to say to the solicitor's firm, well, we require full disclosure of the case file, when the reality is that most of the case file is not relevant to yourself. Most of the case file is not being complained about. It's only this one particular aspect that's been complained about. And I can understand why you would design policies that say, well, we don't want the whole case file under those circumstances, because, it would be, like a data protection issue and burdensome more upon yourself to require the whole case file because the whole case is not being complained upon. Is this one particular incident that we would just want to make an evidence request for? Now, under those circumstances, I understand that your policy would be reasonable and justifiable. However, those are not the circumstances under the present complaints that I've brought with yourself. My complaints are the entirety of the case file from its inception on the 1st of April 2021 until the final until our last final correspondence with the solicitor's firm back in June. So hence why there are over 20 complaints. And as I have explained to yourself, I mean, number one, the case was not running for many years. It was already running for like at most 6 months. And obviously I remember the case fully. And so I think the approach that you've taken is that to say that from them, I mean, one of the problems is obviously as a client, I have a right to the case file, which they're preventing from disclosing to me. Now, the reason that that's problematic is because one of the problems is that they've refused everything. And by them not disclosing any information to me first, it's that they can always backtrack on what they're saying. And evidence can be falsified. Especially documentary evidence can be falsified. And so that's the problem I'm having here, is that on the one hand, the approach taken by the Ombudsman is one which is on the surface of it quite reasonable. But under these circumstances, you've accepted that the complaint is complex. And your definition of the word complex is arising from that it's like multifaceted, namely there's over 20, like there's 20 complaints, so that's what's making it complex. Now, we had this discussion last time, because my understanding of complexity is because when there are many other agencies involved, or many other people, or many other events. This is just one case file with the solicitor. Now, the approach that you've taken is that you're saying, well, give us piecemeal information. Now, I think that approach is like from the asking for them. You've decided not to ask for the case file, because obviously I've raised these complaints. If you've asked for the case file, then at least that's another avenue for me to get my evidence or case file from them. But the approach that you've taken is piecemeal. Like, for example, well, only on the points that we've highlighted to provide us with that information, and that's the evidence request that you've made from the other party. Now, I don't think that's a reasonable approach given the over like holistic approach. Now, similarly, from my perspective, I've handed you over the whole case file, all my evidence. All right, and that is like from the beginning to the end. All right, and as you can appreciate, that was like numerous voluminous records that I've kept. Now, I'm just conscious of the fact that in order for me to progress this matter, you may or may not be aware that in our particular conversations, I've spent over 10 hours of my time in order to raise this complaint with yourself. And you're rightly saying, well, you have chosen to bring this complaint to us, and obviously you have to give up some of your time and resources. Now, I understand that, Sian, that's not a problem. The only problem is that my work here, like highlighting this complaint to yourself on the Ombudsman, is not being remunerated. All right, my time and resources are not being remunerated, and ultimately, effectively, I'm doing this as a public service or a public good, because obviously this is a solicitor's firm that I feel are acting with malevolence. Now, if now on the other side the other party can say that equally the same thing. They can say, well, we're not getting paid for dealing with this complaint that you brought with to the we're not getting paid for our time and resources as a solicitors firm because you brought a complaint to the ombudsman. So it's not fair on us and it's not fair on yourself. However, that's not correct though, because the solicitors firm do get remunerated for their time, because that is a cost factor in the service that they provide. That's all okay, because and this is what I was trying to like emphasize to yourself last time. The approach taken by the ombudsman is that I myself, the complainant, and the solicitors firm are in the eyes of yourself an equal party, and you're an impartial arbitrator. It seems to me that you're effectively acting like a judge then, and you're not a judge. You're an investigator of my complaints, and I can understand why a judge would be impartial to both parties and stuff. But I think the practical realities are this: that the solicitors firm got paid for the evidence that they created, number one. Number two is that any work that they have to do it under like statutory regulations, such as they have to be registered with the solicitors regulatory body, and such as they have to have formal complaints procedures in place, such as they have to obviously pay taxes on the work that they do. So they're a professional corporate organization. And so therefore I think it's highly discriminatory on the approach that the ombudsman is taking, whether you're trying to view me as a private civilian in the same light as a corporate organization which is financially funded and remunerated. So this is the problem I have. So one of the problems is the approach that you've taken in the evidence gathering. As I've explained, the complaint is from start to finish. Therefore, on your part, you should make a request for all the case file, because ultimately they are going to have to go through all this case file. The problem I have is that if they don't provide the case file to me directly, as I have made previous requests, and then subsequently as I've from yourself, then obviously it gives them an opportunity to backtrack, and that's something that obviously is I think reprehensible, because people can falsify evidence. Now from my perspective, I'm trying to make it as efficient or least resource intensive from my perspective. So I've provided you with the full list of my evidence. One of the things I can't do then is I can't backtrack upon it. I can't falsify it. I can't, manipulate it, because it's all there available, and that is like an agreed fact or a foundation upon. Now, your approach seems to be highly prejudicial and discriminatory against myself, because now you're asking me to go spend more time and resources going through all the evidence, like time stamping it and everything like this. And my argument would then be that this is not a courtroom of law. I'm not here to prove anything. All right, I've laid these complaints, and the only analogy that I can give is that I've raised these complaints. I'm incentivized to raise these complaints because that's my right, and ultimately it comes down to what is my motivation of raising these complaints. The very fact that I've raised these complaints and the other party are saying, nah, we don't agree to any of them. We think we've done a perfect service. Remember, you have powers over them. You don't have any powers over myself. Now, in the manner in which that you're asking me to say the fact that I've provided my evidence, okay, it's there available to yourself. Now, you would like me to go. You would like me to go through each one of those points upon your evidence request and timestamp it for you. Now, my only concern is that that's going to be an exorbitant amount of my time and resources. And I can't, I'm just difficultly trying to justify how that could be possible, where I am not required to provide anything other than the complaints that I've lodged. The burden is upon them because they are a body that has the evidence. So they automatically have the evidence. There was no expectation of me to have any evidence. So I think the policies and procedures that the Ombudsman has designed are, highly disadvantaging and prejudicial towards the complainant and in defense of the solicitor's firm. And I think it's just basically, you're placing me into a situation where effectively, I'm not in a position then to provide the evidence, which would then encourage you to, not uphold my complaints. And I think that element is quite prejudicial. And I just need to make you aware, Shan, that the reason that we had this discussion last time, and you said, well, why don't you pursue, parallel other complaints, is because I have a grave deal of concern regarding the Ombudsman, because the Ombudsman, as much as many other organizations, are not doing their job effectively. And that's what I'm trying to establish, because I fully understand what's gone on here. I know from day one, from my recordings, I know from day one, from approaching the solicitors firm, that they were gonna act with malevolence, because of the fact that the manner in which that the case had proceeded prior to their involvement. I was effectively railroaded into getting a solicitor's firm. For the case had been my mother's case had been with the Court of Protection since 2018. For several years, the judges and the local authority and all other parties were effectively trying to railroad me into getting a solicitor. One of the problems I have with the solicitors that I choose to get is the local authority effectively buys them off. So that's one of the reasons that I was slightly apprehensive about, approaching the solicitor, against legal representation. And lo and behold, when I was left with no other option but in order for me to see my mother, which was effectively being blackmailed into getting a solicitor, the solicitor's conduct and behavior from start to finish was highly dubious and they basically acted with malevolence against myself. So we're at this stage now where I have spent over 10 hours trying to highlight these points to yourself. It would be highly unreasonable for the Ombudsman and the Ombudsman's procedures to require my evidence, because any evidence that I have, you already have access to from the solicitor's firm. And the fact that you've taken the approach not to request a case file, as I've explained, because the case is not very large, number one, and number two is from start to finish, that you could effectively ask for the case file, and then I could help point out point out the issues there. But you're not taking that approach. And also, you're also not taking the approach of looking at my evidence, and you're asking me to present more time and resources into this. So I feel from the approach that's been taken by the Ombudsman that this is highly prejudicial, number one. And number two is that if this is prejudicial against myself, remember, I am fully aware that my mother was murdered by the several joint enterprise authorities. So that just consists of not the solicitor's firm alone, but primarily the judiciary, the senior judges in the case, and obviously the local authority who spearheaded it all, and including various other organizations who are equally acting now, like nothing's happened, or not acting appropriately. My mother's died. At a minimum, an inquest should have been held. I've further gone and provided you with further evidence outside of what you've requested, to provide you with the context and perspective provide you with the context and perspective of the circumstances leading up to my mother's death, which was obviously, I reported the matter to the police. I've obviously highlighted the issues in court. And raise those concerns with the police, and each party is not acting with is acting effectively with contempt against us. So coming back to the point of your evidence request, well, it is not my policy to give you evidence requests until I see the other party's evidence request. So can I just ask, they were required to comply by the 9th of May. Have they complied to your evidence request?
Okay, just obviously there was a lot of information. Listen, I fully appreciate your comments that you feel that we're not investigating it how you think we should investigate it. But I am following procedures. These are our protocols. As an organisation, we are an independent party. We do treat complainants and service providers equally. if the shoe was on the other foot and the service provider said, here's the, hours of our conversations, I would be saying the same thing to them. It's not suitable to present evidence to us. I've made it clear how we want the evidence.
But
And I would expect both parties to comply.
sorry, Shan, to just interject there. I do apologize for this, but the reality is that it's that element that I believe is prejudicial, where you're saying that both parties are equal. That element is prejudicial by its very definition, because both parties are effectively not equal. One party is a corporation entity, the other party is a natural person, a civilian. So by your acceptance that you're treating both parties equally, that is prejudicial in my understanding, because both parties are not equal. We're not two different people. It's not two different like civilians coming before you. One is a legal entity, corporation, which is obliged by regulations and statutory, and the other party is a free private citizen. So by you accepting that you're treating both parties equally, that's prejudicial in my eyes.
Okay. And like I said, in terms of everything else, I get what you're saying. We treat them equally when it comes to an evidence request, okay? This is a situation, this is the stage we're in. Now, at this time, though, Mr. Sim, what I'm concerned about is that we're not going to be able to investigate this complaint. And listening to your comments last week and this week, I don't think that if we were to investigate this complaint, we're going to reach any kind of successful outcome for you, an outcome that you're asking us to look at, or carry out the investigation how you think we should be carrying
Just
out
one
the
second.
investigation.
Just before you continue with the conversation, because I do understand from your conversations that you made last week that you were trying to set me up effectively to fail. Can I just ask, before we move on, the other party was required to comply by the other party was required to comply by the 9th of May. Have they done that?
They haven't sent me the evidence as of yet. They've
Okay.
asked for an additional couple of weeks, and I've accepted that.
Under what grounds?
That it's our investigation, we can decide that. There is lots of complaints that have been raised. Had you made the same request of me, I would have accepted that as well.
Okay, can I ask?
And I can still accept that if you do want some additional time.
Can I just ask what grounds have they given?
That they need time to gather the evidence, the specific evidence I have asked them for on all 20 points of the complaint.
Okay, and how much time have they requested?
A couple of weeks, and I've accepted that.
Okay, but clearly a couple of weeks can be 2 weeks, 3 weeks. I mean, you gave them a deadline of the 9th of May, and so you've accepted a couple of weeks. So what date have that been changed to?
Well, they have asked till the 25th of May, but what I'm going to advise on Mr. Sian is that although they've asked for that and I've accepted that they can gather the evidence, I'm now going to do a different process in this complaint. So based on the conversations we've had, I'm going to ask an ombudsman to review your complaint, because I don't think that we should continue the investigation. I don't think that we're going to reach an outcome that is going to be satisfactory for you.
No, that's not correct.
Resolution
Well,
for the case.
Well, I think this is the concern I have. I think this is a whitewashing exercise. I've spent over 10 hours bringing the complaint to yourself. The outcome I would like is for my complaints to be upheld. That's the outcome, and you couldn't reach that. I've spent over 10 hours bringing the complaint to yourself, and then as a consequence, I bought that's a taxation of my time and resources. Now they have argued that all 10 complaints are, all 20 complaints they don't agree to. So I bought the complaint to yourself. You've spent all this time, over 10 hours, speaking to me directly. And now you're telling me that you're not gonna. And do you remember what outcome I was asking for? I was asking for, obviously, to my complaints to be upheld. So why would that be a problematic for yourself to take a different approach?
During our conversation last week, you expressed, you mentioned a number of things, again coming back around to the fact that you think that the motivations behind the firm, they were in collusion with the court,
yes,
and that you said they were malevolent, and ultimately you would want me to identify that,
no,
and report it to a higher service, and that I was obligated to report to a higher service.
Well, I mean, I explained to yourself that my mother's death has not been investigated by the coroner. Number one. this is the first opportunity that the matter is being investigated by yourself. And obviously, you've made me aware that the maximum penalty that you can prescribe on the solicitor's firm is £50,000, isn't it? That's correct. That's correct.
That's our maximum
Yes.
financial compensation.
Yeah, maximum finance. Because otherwise, what would be my motivation in bringing the case to yourself? Can I ask, what is the motivation of members of the public in bringing a case to the Ombudsman?
There's a number of reasons, and normally people come in with an idea of a remedy that they want. So perhaps a refund in fees for the solicitors to continue the service that they've to complete the work that they've started out to do for the complainant. There are a number of reasons why people bring complaints to us.
Okay, sorry to interrupt. But ultimately, it's financial based, isn't it? Whether they want the refund, obviously, as you can appreciate, under these circumstances, I didn't pay them anything. All right, so that's not. But ultimately, in order to bring a case, it's either punitive damages or a penalty to them, or financial, or like such as a civil case. So there may be another number of individual factors that the person would like to, as a resolution, but ultimately it's a financial remedy, isn't it? It's not a criminal case.
Not necessarily have to be financial. There are a number of non-financial things that we do. Sometimes people just want a written apology. Sometimes people want certain documents that the firm are holding for them to release the documents. So there are a number of non-financial remedies as well that we can achieve.
Okay, because if it's regarding document disclosure, then obviously they have a right under the subject access request for any documents, okay? And like I said, primarily it must be financial rather than any other piecemeal kind of issue with yourself, because but under these circumstances, I've been open and transparent from yourself from day one that I've approached, this matter's been with yourself now since January when the case was handled to yourself. It was obviously brought to yourself in August last year. And obviously, this is a very serious matter, and I cannot highlight the seriousness and severity of the situation that's been created here. Like, there's been a death of somebody, and I've been making claims that it's murder. I've also then given you evidence. I've gone to the police regarding this. So ultimately, when I'm asking for a remedy from yourself, I'm just trying to provide you with the context and asking you the outcome that I would like is for you to look into the matter and uphold my 20 complaints. That's all. I've never asked you for anything further than that. If there was anything further, and I've highlighted, if there was through your investigation, if you found that there was something serious, then quite rightly that matter should be reported to the police. Because I've tried to report the matter to the police with little effect. So I'm just struggling to understand why you're at this stage, looking to effectively shut down this complaint.
Well, listen, what I will do is I will send this all out to you in writing, and I will allow, we normally say a couple of weeks for you to raise, send off your written comments to say why you disagree with my decision. Again, I'll reference our scheme rules. So I'm not sure if I've discussed our scheme rules previously, but they are the rules that we kind of run the organisation on. They're what passed in Parliament. So we can only dismiss a complaint if we think it falls under some of our scheme rules.
Okay,
so
right.
Reasons that aren't appropriate for us to investigate. So I'll send you a copy of that with the letter.
Well, can you...
I have to notify the firm as well as my intention. Obviously, the letter will explain things in a lot more detail. It will reference the scheme rules that I think this falls under. But also what will happen is, I will absolutely allow a couple of weeks for you to provide comments to say why you disagree with my decision. For example, you could come back to say, well, we've been discussing this for 10 plus hours on the phone, X amount of months, why are you dismissing it now? That can be your comments that you can raise. And then I would pass that to an ombudsman. So it will be an independent ombudsman that's not had sight of the case previously. They will make a completely independent decision.
Just hold. Okay, sorry to interrupt there. You mentioned this last time. I, as you can appreciate, I've written out to yourself. I've included the ombudsman. The ombudsman is Paul McFadden, isn't it?
He's our chief ombudsman. So
okay. How many ombudsmen? Because I presume that it's the chief ombudsman that you work for. Do you not work for the chief ombudsman?
We do, yes. So
yes.
We have a chief ombudsman, and we have a number of other ombudsmen that are under him. and then we have investigators who are
Yes,
that I'm part of.
yes, but ultimately, obviously, I can't. It's not the procedure or the correct procedure for me to speak to the chief ombudsman, is it?
Well,
Right?
this will go to an ombudsman.
No, no,
You can
no,
dispute their decision if you want,
no.
but obviously.
What I'm trying to say is that there's only one legal ombudsman, isn't there? That's the Paul McFadden, the chief ombudsman. Okay. Obviously, as you
No,
can, yeah. Sorry.
sorry, there are other ombudsmen. There are a number of other ombudsmen that work for our organisation, but the chief ombudsman overlooks the organisation. So he doesn't get involved in decisions or complaints. He will deal with high up service complaints. So it might be that you want to raise service complaint, but we have other ombudsmen who will actively work on cases.
Okay, how many
high complex issues.
How many ombudsmen do you have?
In all honesty, I couldn't give you an exact number, but there are a lot of ombudsmen, maybe 40, maybe.
40.
I don't know the specific number. It's not
Oh, what's the name of your ombudsman that you work under?
Well, I don't work under an ombudsman. I work under a team leader manager, so I can share their details with you if you'd like.
Yeah, sure, go ahead.
So have you got a pen and paper to hand? I can also send this to you by your email as well.
Okay, all right.
Their contact details.
So can you just tell me the name? Yep.
So do you want me to send it to you via your email and to send a copy of his email address?
If you could do, yes, but could you just give me the name over the telephone now?
Yes, of course I can. So it's J.
Yes.
OSEI22. So that's OSEI. OSEI.
Okay.
TUTU.
OSEI 22, yes, that's your manager.
Yes.
Okay, all right.
Correct, yes.
Okay, all right. And so obviously your sorry, you sorry, go ahead. Go ahead.
But he is my manager directly. So if you feel that you're dissatisfied with how I've handled this case, or there's a complaint against myself, then you would go to him directly.
Okay.
In terms of this decision, it's my decision as the investigator, but it does go to an independent ombudsman to make the overall decision. It might be that they agree to dismiss the complaint. It might be that they say no, there's not enough grounds to dismiss the complaint. We have to continue, and in that case, then I would continue the investigation.
Okay.
But it can't be dismissed unless an ombudsman makes that decision.
Pardon?
It can't be dismissed unless an ombudsman makes that decision.
Okay,
so
all right.
Although I'm going to request it, I do not have final say over whether that complaint is dismissed. I just put forward the case that I'm the investigator on.
Okay, all right. So can I ask, all right, that's just so I've got the name of your manager now. Can I assume that since you've been assigned to this case that your managers had oversight over this case?
So we look after these cases. So he hasn't had to have any involvement in this one. We've been going along unless customers contact them or say, I want to speak to your manager or something like that. They wouldn't necessarily get involved in our cases. We look after them and run them. Okay, all right, that's all right.
So under these circumstances, you've been involved in this case at this stage. Your manager's you've not had briefings or conversations with your manager or anybody else regarding this case, yes?
Correct, yes.
Okay, all right.
I've just been the only investigator on this case, yes.
Okay, all right. So up until now, we've had quite lengthy conversations, numerous calls, and we've made an evidence request. I've complied to the evidence request. Can I just, and this is the first time, obviously the point of the call today was for me to understand, for you to get some information from the ombudsman. That's why we left things last time. Now, can you help me understand over the telephone right now why you feel that this complaint should not be continued with?
Yeah, so there are a number of reasons. So what we've discussed there from our conversation last week that you highlighted to me. And again, this is my interpretation, and this is why I'm putting it in as one investigator. I don't think we're going to reach a suitable resolution for you. Some of these complaints as well, I don't think are going to amount to poor service. But there's other reasons. So, the disagreement we've had about process, the disagreement we've had about evidence. I won't be able to, have to share your evidence if you supply any with the service provider. It's not going to be a case that I'm going to request a case file. I have asked for specific pieces of evidence per complaint. So there are a number of reasons, and like I said, I will properly outline this in a letter to you, because on both sides of it, they're going to have to reference our scheme rules as well, which again,
Okay.
they are the rules that we
Well,
go by. And if you have a copy of that, you might be able to understand it better.
okay, well, I mean, I've got you on the phone now. I mean, you understand the scheme rules. You must have applied these because I, from the approach that's been taken, I believe there's something malevolent going on because, as I've explained, that there's something serious afoot here. But if you can just try and tell me now, what scheme rules have not, because you've not brought these scheme rules to my attention. Obviously, I've been acting in good faith by approaching yourself, and at this stage, at the last minute, when evidence has been presented to yourself that obviously fully corroborate all my complaints, at this stage you've taken like U-turn. It is correct that prior to this call today, this is a complete turnaround of events, isn't it? You've made a decision. Can I ask first of all, when was that decision made?
Sorry, say that again, Mr. Say. So I haven't reviewed any evidence. Yeah, I can't. I mean, I cannot actually. I cannot access your YouTube channel through my work system, so I haven't had sight of any of the evidence or anything like that. As far as I'm concerned, unless they're submitted in MP3 format, I'm not going to listen to those audio files.
But the reality is that when we spoke last week, you said that you told me, you made me aware that you're not gonna be in a position to view the YouTube videos, but you did say you'd go to IT to find out if you'd be able to have access from them.
Yes, correct. And obviously, I've also got Ombudsman, some advice from an Ombudsman in terms of our process about evidence. So I wanted to ensure that, again, being the investigator, that I was correct in what I was saying, that we're not going to listen to audio files.
Okay, that's fair.
That's incorrect.
That's fair enough. So, what was the name of the ombudsman that you went to spoke to?
Just bear with me, because I have to access my system. But it was an on-call ombudsman. I'll have to go in and get that. I'm not sure if I can share the name with you. I'm sure I can. I'm sure that'd be part of the subject access request, because if you have a subject access request with us, I'm not too sure if they share every single name of a person who's ever dealt with your file. So I'll have to double check on that.
So at this moment, you can't tell me the name of the ombudsman that you sought advice from?
No, but I will go away and ask that question. I know that's part of the subject access request.
Okay, all right. Well, fair enough. I mean, because, all right, so I understand this now. Can you understand? I'm slightly taken aback because this is like what I had anticipated from the beginning. Because obviously, I'm concerned that you've made a decision, and I don't accept that this decision is being made upon yourself. So, can you tell me which scheme have you relied upon? You've mentioned these schemes that circumstances where you would not look to pursue the complaint because, as you can appreciate, when I first brought this case to the ombudsman back in August, initially they told me that we don't investigate complaints for against the official solicitor. Is that correct?
That's correct. I think that was some misunderstanding regarding your litigation friends. I think we call it like a general inquiry seat, so they don't really look into the case, in the detail and investigate to it. But I think their understanding was that you were making the complaint against your the person who was your official solicitor, so your litigation friend, and it is part of our rules that we wouldn't look into those complaints.
Okay.
But obviously that was established. You came back to say that wasn't the case. So
yes.
Obviously, that then continues.
Okay, so can I just ask? I mean, I'm just slightly would like to know if there is any impropriety by the official solicitor. Then who investigates that?
I'm not too sure. That might be that you need to go to. You'd go to the SRA in the first instance. I'm assuming because they are the regulator and they will review any conduct by any registered solicitor. So again, where we said you felt that our powers are limited, the SRA would investigate conduct issues. So I believe they would be the authority that you go to on that point.
But where does your role come in then? I mean, like, what I'm trying to establish is that I was slightly taken aback because, as you can appreciate, on this case, it was a crossover because half of it was done while I had passed, whilst I had given instructions to the solicitor, and then starting from like October, November time, the case had then been passed over to the official solicitor. So it was like a crossover between one and the other. Now, with regards to the official solicitor, your organization, the legal ombudsman, do a completely different role and have a different remit to the solicitor's regulatory body, don't you? You're two different bodies for a reason. So your remit is very different, very different to the SRA. Now, what I'm trying to understand is the remit that you cover. Obviously, it does involve bringing, investigating complaints against solicitors. That is your remit, isn't it?
Yes, for any
Okay.
service complaints.
Yes.
Anybody who's SRA registered. Yes.
All right. But can I confirm that the official solicitor is registered with the SRA?
Well, I'm not too sure. We'd have to look into the official solicitor. I've not looked into your official solicitor that was assigned to you.
No, it doesn't.
We're investigating things.
The official solicitor is it doesn't matter which solicitor is they involved with. You've just basically told me that you don't investigate the official solicitor, which is a post. It is like an office, isn't it? Of official solicitor. I think it's named Sarah Castle. That is a specific post. Whether they delegate onto other solicitors is irrelevant. I mean, even if they had delegated onto other solicitors like Bergniazi, under those circumstances, you would not investigate them. So, for example, if
Sorry, Mr. Say, I understand what you're saying now. So the official solicitor has been assigned to you by the Court of Protection. So we don't investigate any solicitor's complaints against any solicitor that's been assigned to you through the Court of Protection. That would be the Office of Public Guardian that you'd contact. So they're a different regulatory body for those specific solicitors that are assigned to you through the Court of Protection.
I understand, okay, but it's just slightly. I'm just obviously doing my own research, and I understand that the official solicitor are not even obliged to the Freedom of Information Act. So this is where this concerns me, is that the official solicitor is not regulated or brought into your the legal ombudsman under the hello. All right, she just cut off. Hopefully she'll come back. What's up from there? Give it a couple of minutes. Okay, no stopping. Oh, hello?
Hello, Mr. Sid. I'm very sorry about that. I think my signal dropped on my side. I'm sorry about that.
It's okay. It's all right. So I was just saying the fact that I'm aware that the official solicitor, which is obviously part of this complaint, was, obviously they took over. And I was just trying to understand for myself that the official solicitor, you don't investigate the official solicitor. The official solicitor is somebody that's assigned by the court, and therefore it comes under the jurisdiction of the court and outside of your remit. Is that correct?
Yes, that's correct. Yes.
Okay, and because it's signed by the court, and also I was trying to explain that upon my further research, I found out the official solicitor is not obliged by the Freedom of Information Act, which is obviously surprising to me because it's a government office. But so I just wanted to know, it just seems the fact that I was allocated this official solicitor under stratagem and design, you see. But coming back to the, so thank you for that understanding. I just clarified a little something clear to me. But as you can appreciate, I mentioned that in August, when I bought this case to yourself, it was misallocated, and then obviously it didn't get allocated to yourself until end of December, and we've been conversing conversing since January. I've spent, obviously, like I said, 10 hours of my time going through a very complex case. Well, it's a like as you explained, very complex in the sense, in the nature of the level of complaints, which were 20. We've had many conversations. We've had an opportunity to put in, like, I think, was it after the event? What do you classify them when I've made more complaints? After the event complaints, or preemptive complaints? Is that correct?
Sorry, yes, premature complaints.
Sorry, premature.
We call them premature complaints.
So you refer to them as premature complaints. Now, obviously, as you can appreciate, I was not afforded an opportunity to present those complaints to the solicitors at the time, because I was following their procedures. But then, obviously, we've gone through this lengthy conversation, and then subsequently, you've made an evidence request. I've looked to comply with that evidence request, and now you've made a decision that you feel that we would not be able to find a resolution. So, and you mentioned that you've based this upon your evaluating some other criteria. You've not made me aware of this, so can you just tell me what you've based this upon?
Yeah, of course, and I can list our scheme rules, but and I could do that now for this mistake.
Yeah, sure.
That I'm going to say that I think these things fall under. However, there's a copy of scheme rules on our website, and I will send all this to you in writing in more detail. With reference to it, okay? So it's not a case of me just telling you now and I'm going to refer it. I'm going to send it in writing and then allow time for comments, because it's important that you have a chance to raise your comments for the Ombudsman.
Yeah, sure. But can you...
Sorry, go on.
So, but could you just tell me now, because obviously a decision has been made. So...
This is a decision from me to put forward to an ombudsman.
Yes.
It's not that your case is being dismissed now. Again, that's not I do not have the powers to dismiss a complaint. I can only put forward a request to consider dismissal, and an ombudsman will make that. Okay. So there was two things. Like I said, we have dealt with it, and I have had some concerns throughout. However, we've gone on in the investigation.
Sorry. You said you've had concerns throughout. So can you just clarify? Can you just clarify what do you mean you've had concerns throughout?
So when you initially brought the complaint to us, obviously you have always mentioned that you felt the firm have acted maliciously, or that they're part of a larger scheme in terms of they were going to work against you.
Yes.
So they've had concerns that we're not going to be able to make that determination, and you've agreed with that as well.
Yes.
However, the conversation that we've had last week, and especially the emails that you sent on following that, that seemed to me that, you also made comments that you would expect us to report to a higher service. If we were to find poor service, I just don't think we're going to reach a suitable resolution. But there are other reasons. So under our scheme rules, we have section 5.7 of our scheme rules, okay? So this is grounds for dismissing or continuing a complaint. So this is where we say an ombudsman may or may not dismiss or could discontinue all or part of the complaint if in their opinion. Okay, there's a number of different reasons. So one of the reasons that I think is that it does not have any reasonable prospect of success. Okay, so this is what I'm saying in this instance. I do not think we're going to reach a resolution that's going to be successful for you. Sorry
to interrupt again. I just need to be really, really clear about this. Now, one of the reasons is that you do not believe that the complaint will have a reasonable prospect of succeeding. All right, that is one of the criteria. Yes.
Correct. Yes. That's one of the reference. That's one of the rules I'm going to reference. Yes.
Okay, so one of the reasons is because you do not believe the complaint would have a reasonable prospect of succeeding. So that is the complaint, not the complainant. Those are the complaints, isn't it?
The complaints, yeah.
Yes. So I put 20 complaints in, and you believe that none of those 20 complaints have a reasonable prospect of succeeding, considering that the solicitor has refused to acknowledge that they're saying no, we didn't. We don't agree to those complaints. So because I've raised 20 complaints, you believe that none of those 20 complaints have any reasonable prospect of succeeding.
So it's not that I'm saying that in terms of the context I'm using this rule in here, though, is saying, is that we say a prospect of success, which you can also relate to an outcome that you're looking for. So an outcome that you would think would be successful, and that's what I'm referencing here. So that's my that's and that's okay. And there are other reasons that I will list as well.
Okay, thank you. I just wanted to, obviously, it's much better when I can seek clarity, because if you tell me something in writing, I won't understand it, and then we'll have to have another conversation. So, it's better that you explain this to me. So you're saying that it doesn't have a prospect of success, and that prospect of success is not the complaint itself, but the outcome. That the outcome that I'm asking for does not have a reasonable prospect of succeeding, and the outcome being that I would like you to uphold the complaints. Is that correct?
So, no, in terms of an outcome that's successful, I don't think that we're going to come to a prospect of success that you're asking us to do. I think in the conversation we had last week, you raised that you would expect us to raise, find the specifics.
Sorry, in our conversation last week, you've made it quite clear what you are and not able to do, and the outcome I'm looking for is for you to uphold my complaints in the context that the solicitors have said that they do not accept my complaints.
And there are other rules that I'm also going to reference as well. So, and this relates to this one as well. And in terms of, so we have a rule under 5.7n that if there was any other compelling reasons why it's inappropriate for an issue to be dealt with by the legal ombudsman. So what's concerning is the evidence issue. So, I know that you've said we're going to disagree on the processes. I don't think we're in agreement of how you think we should investigate this complaint. I don't think that you're satisfied with the evidence request I've put forward, and that you're not satisfied that I've said I'm not going to accept a YouTube channel as evidence. That I've requested MP3 files.
You've told me today that you're not going to accept the YouTube channel as evidence. You've told me that today, haven't you? Because you were supposed to find out last time. So you told me that today, haven't you?
Right, and you've come back and said that you have provided the suitable evidence, and that is fine.
And the reality is that I've explained to you that I've had that evidence, and in the absence of that, if you're not willing to accept it, I'm not obliged to provide you with any evidence, am I? We had this conversation last time that if I don't provide you with any evidence, your decisions will be based on the evidence that the other party provide.
Well, we can also make a request of complainants as well. It's in terms of what absence is the evidence. So listen, I am going to send this to you in writing. If I know you just mentioned there that you would prefer it wasn't in writing, am I best to send this in audio format? Because I think I need to send out a list of reasons written.
Okay. I mean, you've provided me with 2 so far, haven't you? How many reasons are there?
That's it. That's what I'm going to reference it on.
So just those. So can I just be clear? Because obviously I just need some clarity of understanding. You made the decision, because obviously I will be looking to contest this, because obviously, like I said, I've put in a lot of time and resources. So you've made the decision that you're advising the ombudsman not to continue with this investigation on 2 grounds. And can you just remind me what section they are again? 5 point something, did you say?
So that's 5.7 the masking rule. So that's under grounds for dismissing or discontinuing a complaint.
Or 5.7, yes. But then there's subsections, isn't it? One is that it has no reasonable prospect.
Correct, yeah.
So what is that? So 5.7, then A, it has no reasonable prospect of succeeding, and B was what was B again?
So it was N. So N for November. Sorry, it is the second one.
N, okay. And what does N mean?
And that was it. There are other compelling reasons why it's inappropriate for the issue to be dealt with by the legal ombudsman.
Okay, and so those are the 2 points. So what other compelling reasons are there? So one is that there's no prospects of succeeding, and number 2 is that there are other compelling reasons why this investigation should not happen. And can you just tell me what those all the other reasons?
Sorry, just so just repeat that. Sorry, Mr. Say, breaking up a little bit.
Sorry about that. So there's two main grounds in it. One is that there's no reasonable prospect of a positive outcome or succeed, no reasonable prospect of success, and the other one is N, where there are other compelling reasons why the investigation should not continue. Yep.
There we go. So you're much clearer now. So I did miss that same thing, but they're the two reasons that I'm putting forward.
Yes. But with regards to the second reason, there are other compelling reasons why the investigation should not continue. Can you tell me further what other compelling reasons? So one of those compelling reasons is that you're saying I disagree with the evidence request. What other compelling reasons are there?
That you disagree with how we investigate complaints. So you disagree with how we're choosing to investigate the complaint. One of the issues being, for example, that you think we should request a case file.
Yes, but
that is an example.
Okay. So obviously, I have a right to voice an opinion. All right. Obviously, yeah. Yes, I've voiced an opinion. All right, and obviously, sorry.
You can completely. You can disagree with this. Absolutely, there's no reason why you cannot disagree with this. I am putting this forward as one person as the investigator. You can absolutely disagree with this, and like we will allow time. I'll allow time for comments to be raised, okay? And again, we notify the firm of the intention as well. The firm can raise any comments that they want as well, but mostly it's your comments because I am saying that we should dismiss this complaint.
Okay.
And obviously you would disagree. So you can absolutely raise comments as, this is a fair and independent process, and that's why an ombudsman will independently consider everything.
Okay.
So listen, they're the reasons that I'm going to put forward.
Yeah, that's fine.
I will write this down.
Yes. Yes, Sian. I mean,
I'll write this down in much more detail.
Okay, that's fair enough. I mean, like I said, thank you for that. I mean, so you provide me with the clarity that I required, because obviously since so this decision has been made. When was the last time that we spoke?
We last spoke last Thursday on the 4th.
So
I believe. Let me just double check that. I'm sure it was Thursday.
Yeah, I think it was Thursday. Yes. So from Thursday to today, that you've made a final decision. I'm not here to trying to change your mind. I'm not trying to. That's already a decision that's been made now, hasn't it? All right. You've provided me with the information regarding why that decision's been made, and you've also advised me on what next steps I need to take if I'm dissatisfied with that decision. But I just wanted to ask that decision has been made in the last week, hasn't it? Yes.
Yeah.
And so obviously prior to that, you also mentioned the fact that you've had ongoing concerns previously, previous to the decision that you've made in the last week. And I just wanted to gain some clarity of what those ongoing concerns have been. So I've been speaking to you since January. My ongoing, obviously, I've mentioned to you that the solicitors is part of a wider joint enterprise that's resulted in my mother being murdered, and it involved the senior judiciary, and obviously I've subsequently last week sent both to yourself and the chief ombudsman evidence of that. Can I ask? That's a concern. That's been an ongoing concern for yourself. Is that correct?
Well, when we discuss the complaints, I have to consider if we can investigate complaints. Absolutely, we keep these rules in mind. Obviously, you have previously made comments about your concerns about the solicitors and what you expect, etc. And so I've always thought they were just in the line, but following the evidence request and the discussion we had last week, I think there were several comments that we've discussed already that I've then decided that I do not think it's right for us to investigate these complaints.
Okay, but I'm just trying to break the things down. Prior to our conversation last week, prior to the conversation, because I'm going to return to the conversation we had last week, but prior to the conversation on the 4th, what concerns have you had about myself or this investigation or your continuation? What concerns have there been? You've mentioned the fact that sorry, go ahead.
No, so it's very similar to the reasons I'm actually going to give now. So in terms of the evidence, you have previously expressed dissatisfaction with the way we're going to conduct the investigation. Or for example, the evidence you've previously remarked, well, I'm not going to submit any evidence. I expect them to submit it, and then I'll review it, and then we'll come back to it. So you've already commented and things on that, but until I make the evidence request, I'm not actually going to know what evidence you're going to submit. So, in terms of that, I'm not going to know until after I've submitted the evidence and we've discussed that. Again, in terms of prospects of success, you previously mentioned it, but I felt like last week you really mentioned what your expectations of us were in the investigation. Obviously, I understand your comments now to say, well, actually, I don't expect you to do that, but obviously I still intend to
sure.
proceed with it.
And
again, you can disagree.
Yeah, sure. But I'm just trying to understand. I mean, prior to my conversation last week, you've had ongoing concerns. I have expressed to you the fact that from day one that you made me aware from day one that you will not be requesting the whole case file. That's correct, isn't it? That's something I've disagreed with you upon from day one. Yes, you said I won't be making a request for the whole case file, and I've highlighted to you that one of the concerns I have is that the solicitors firm have basically are withholding information, which I consider is an act of fraud by false failure to disclose information. Now you've advised me. You've said that we've had this conversation in the past that look, Mr. Hussain, I'm not going to investigate that as a poor service because there is another avenue open to you, which you have mentioned to me regarding going to the Information Commissioner's office. So you've made a SAR request. I don't want to cover that aspect. You've advised me that you've taken the matter to the ICO, so I won't be doing that. So I've explained to yourself that okay, that's fair enough. But I think under these prior to today, I've mentioned to you that I would think that if they're being investigated, and remember that the case file that you're saying that I'm not making a full request for. In this conversation today, I've highlighted why you would not ordinarily have policies in place to ask for the whole case file, because if it's only one small matter, but under these circumstances I feel it's justified to ask for the whole case file because of the fact that there was the complaint from start to finish. But anyway, you've made me aware that you won't be asking for the case file in its entirety. That's something I've disagreed with you upon. All right, I'm being very vocal about that, but me disagreeing with you, I've explained to you that I can't force you to do that. Why would that be a concern? Because I think the approach that you're taking from day one, effectively saying, well, I'm not going to be asking for the case file, has put me in a prejudicial situation. And the reason is because, you see, one of the concerns I have from my own personal experience is that when I present some evidence, then they backtrack and not in just in Burke Niazi's case, in other dealings with the local authority and all the other parties, they can then backtrack. And obviously, I don't want them to be backtracked. So when you've made me aware early on in this, in our interactions, that I will not be asking for the case file, I felt that was slightly prejudicial on your part against myself, because obviously, and I've made that clear. So I have a right to disagree with you, and I equally disagree with you right now that your aspect of not asking for the case file is placing me in a prejudicial manner. In a prejudicial situation, because obviously this is my evidence. And also why I'm concerned is that the Ombudsman does not have a sophisticated policy in place dealing with complex cases such as this, which is from start to finish. And as you can appreciate, Sian, that these are documents that are created at public expense. So it was legal aid funded. So these are documents that should be made available. And what concerns me throughout, which obviously I'm slightly perturbed that you've not picked up on, which I have had to highlight to you, is that the solicitors are doing everything in their power and remit to add time delays. So obviously, when you've made me aware, it's our policy that you've made now preemptive complaints or further complaints. We need to give them further 8 weeks. They could have come back earlier, but they didn't choose to do so. And I've highlighted to you that is indicative from my perspective, and it's my opinion only. And obviously, they are following the procedures, but it highlights to me underlying guilt on their part, where they're trying to be evasive. Now, remember, this initial complaint was lodged with them in November 2001. I followed their procedures, where I had to then, send it back to them, go through their formal complaint procedure, which is not like instant. It takes a couple of months to go through their complaints procedure. I had to exhaust their complaints procedure before bringing it to yourself. Obviously, subsequently, the problem here lies in that there was no cut-off date where my services ended with them. Effectively, when I was complaining, I was still under, like, they were still providing me with the service via the official solicitor, and the service didn't finalize until July last year. So those were the problematic issues. But I highlighted to you the concerns that these are the substantial amount of delay that they're taking. Hence why in this call today I've said to you, or you gave them a deadline of the 9th. They've asked for a couple of more weeks. Now, I don't think that's justified, because the reality is that they've been aware of these complaints for a number of times. It's not a big case file, and like I said, I can understand if it was many years of the case was with them. They have the case file in front of them. I feel the fact that I feel the fact that the case file is the evidence against them, which is not being collected by yourself. So I've made that quite clear. I've expressed that opinion to yourself. Why would that be a concern? I have a right to disagree with your policies and procedures.
Yeah. What I will say, Mr. Sian, is obviously I'll get this letter out to you listing the reasons. You absolutely can disagree, 100%. If there's any issues that you have that you think that, reasons you think I've not properly dealt with the case, obviously I'll give you my manager's name. I will also give you their contact details as well. And I'll notify them that, you've expressed some dissatisfaction.
Okay.
So they might be in touch with you. But
okay.
You can absolutely tell them that you disagree.
Okay.
Raise those issues. They'll look at it independently. And in terms of this, again, this is just me as an investigator. This is my views.
Okay.
If an ombudsman, this is why I pass it to an ombudsman. They're completely independent. They will make that decision. As not being involved in the case, they'll take all your comments on board. If you request them to listen to specific calls or whatever, they have access to everything on the case.
Yes.
So I'll look to try and get that out to you as soon as possible.
Okay. All right.
And again, I will follow it up. I'll follow an email up just after our call now with my manager's contact details, and you can contact them directly.
Okay. So can I ask, on a personal level, have I been rude or disrespectful or discourteous to you throughout the conversations that we've had? Have you felt intimidated by me, or have I done anything untowards you personally?
No, I don't feel like our calls have been discourteous at all.
Okay.
I hope you don't feel the same. I don't think there's been any aggression or anything like that from my side. I hope that's not the experience you feel either.
So, I mean, the decision that you've made, basically, the reason I'm asking that is the decision that you've made is not being based on my personality or, the way and manner I've spoken to you, like if I've been aggressive or abusive, or and that's prejudiced your decision. It's got nothing to do with that, has it? I mean, like, I've been. Would it be fair to say that I've been nothing but professional with yourself?
I absolutely will not be referencing anything in
No.
This is purely a decision based on. There's been no issues whatsoever from my side. Happy to advise that to my manager if you contact him. There's been no issues in terms of abusiveness or anything like that. Hope you're not feeling safe. And again, when you receive my letter, you'll see that there won't be any reference to that. It's not the rules that I'm referencing in my choice to try and dismiss it. Okay.
No, I'm just trying to understand that I've not threatened you or intimidated you or acted in in any manner that you would not expect from a complainant.
No, there's been no threats.
Okay. I just wanted to rule that aspect out. And secondly, that I just wanted to, I think we should look to end the conversation now. I don't want to take much of your time, but I just wanted to discuss the conversation that we have had last week. Okay, because obviously the last week you've asked me you were asking me quite clear questions, which I perceived as staging questions, because you asked me, Mr. Sian, what is the ultimate outcome that you want? Do you remember asking me that question?
Yeah.
And I believe that was a staging question to effectively undermine my case, because I was very, very clear. You've been very, very clear from the onset of what what you can and cannot do. You've also made me aware that what is preventing me from pursuing legal action concurrently. You've said to me that you don't have to wait until our decision. You can pursue legal action concurrently. Do you remember that conversation?
Yeah.
Yeah, okay, so it seems to me the fact that, and this is my own personal opinion now, so obviously I'm just trying to highlight the situation here. I don't think this is your decision. I don't believe it would be your decision. It's my opinion that this is a whitewashing exercise, and the decision has been made by a higher authority, and you've been tasked to say that it's your decision because based I'm objectively speaking, based on the information that I've spoken to you on, I've not been rude or disrespectful. And we've had a 10-hour long conversation throughout this time period. I don't think any reasonable person would have made the decision that you've made the decision on. I therefore must conclude that this is a decision made by higher up, and you're simply tasked to do this. So the aspect of me complaining to your manager is once again an exercise in futility, because I believe that your decision has been orchestrated from a higher position in order to whitewash this case. And that's my opinion. I mean, obviously, I'm just expressing that opinion to yourself, just for you to understand that this is not the first time that this has happened. And obviously, based on what you've told me right now, that it's nothing to do with me personally. It's not like anything I have like said to you or been aggressive towards you in any manner. Based on the facts of this case, that I have been open and transparent with yourself. I've provided you with all the information. I think any objective, reasonable person would not be in a position at this stage to make that decision, because following my email last week, where obviously I've provided you with further evidence, which and the purpose of that was not to to aid you in the complaints that I had lodged. I made it quite clear that I'm providing you with the wider context and perspective. We had this conversation last week, so given that information, and I had also included the chief executive, as you can see from my email, Paul McFadden, who's the chief ombudsman, that based upon based upon my emails last week, I believe a decision has been made from higher up just to simply to like end this investigation. And obviously what you're telling me is for me to go through the formal procedures, and that's what I will unfortunately have to follow, because that's what I've been trying to do from day one, is to follow your formal procedures, not just your formal procedures, but follow formal procedures in the court of protection, in the solicitor's complaints procedure, in the manner of bringing this case to yourself. It's just simply follow formal procedures. Obviously you've made me aware today that of the grounds of your decision. I don't think those grounds, the decisions that you provided me are reasonable at all. But because you've made that decision, I believe that has been placed upon yourself. When I do put in a complaint, which is going to take more of my time and resources, I believe that the ombudsman, whichever ombudsman is simply going to disagree with me and side with yourself just to bring up this matter to an end. And that's what my views are. So I think throughout this case, there have been external involvements. Particularly, that was the whole point of me bringing this exercise to yourself, to see as upon myself being most reasonable and accepting of the procedures, and being an educated person, and being determined to bring this case to yourself, for it to be whitewashed. It's not, and I have to take into consideration that I am not only bringing this case to yourself in isolation. As you can see from evidence presented to you, I brought this case to the Greater Manchester Police, I brought this case to the West Yorkshire Police, I brought similar cases to other organizations. Each and every one seems to simply whitewash the situation. And so I was anticipating the situation now. I had believed that you would look to whitewash this after your findings, but we're not even going to get to that stage, because at this stage you're not even willing to investigate the evidence, and you're bringing it, and I think it is premature of yourself to have made this decision. So I think that's just my opinion, that I don't think that this decision is your decision in isolation. I believe it is a decision by the senior people who have asked to have this case shut down because of the consequences it brings, and the highlights to the judiciary. Ultimately, the judiciary have been bought off, and as a result of which, my mother has been murdered. So, just to express my opinion, I don't believe the decision is yours in isolation. However, I must go upon what you're telling me, that you alone have decided this, based on the criteria that you've highlighted, namely that there's no reasonable prospect of succeeding, considering that you've not even given me the opportunity to present to you evidence in your format, namely, time stamping and everything, because that's what you've mentioned to me today. But you've told me in this conversation that the decision was finalized prior to the call today. That's correct, isn't it? Your decision to stop or bring an
yeah, I mean, just obviously, I'm conscious of the time is the same, but and I think that is absolutely your opinion, and you can disagree completely. In terms of I will write to you regarding the evidence. I mean, if you were to send us the evidence in the meantime before an ombudsman reviewed it, then the ombudsman cannot consider that as a point for dismissal because you're willingly providing that evidence. So just to note on that, obviously, it will be something that I reference in my dismissal letter to you. But if you were to share the evidence before that time, then you're demonstrating that you're happy to comply with my request, and the ombudsman cannot dismiss your complaint on that basis. Then, so
sorry, Chan. But the decision to discontinue this case was made before the call, wasn't it? You've not made this call. You've not made the final decision during this call. You made the decision before this call, didn't you?
That's my decision. Yes.
You made your decision not based on this hour-long conversation.
No.
Yeah.
You're right. I've made that decision based before this call.
Before this call. Yes.
Your comments today have also reaffirmed
yes.
my decision. That's why I'm
yes.
referencing. Yeah.
Yes. So you made the decision. Sorry to interrupt, Shan. You made the decision before this call, and during this call, you then told me that this is how I want the evidence, and it's during this call that I've had I've questioned that. So that cannot be based on your decision, because with regards to now you're telling me that if I do provide the evidence in this format, I think. But like I said, but in the previous call, in our previous conversation, you said that I don't necessarily need to provide you with any evidence. You said I've made an evidence request to you, and this is a conversation we had last week. If you choose not to provide any evidence, that's fine as well. I will go and make my decisions on the evidence provided by the other party. So why would that, if I look, for example, Shan, I'm telling you, if I was to say to you, nope, I'm not going to provide you with any evidence, why would that be grounds to shut down the investigation? Because you can proceed to the complaints I've read without any evidence from me, can't you? Hello?
That is just an example of where I've said that you disagree with our processes, and I don't think you'll be happy with the way we investigate the complaint. So that is my opinion. That is what I'll put forward.
Yeah, that's fine.
You can absolutely disagree. I appreciate your comments. I'll get this letter out to you in the next few days. I'll let the firm know that my intention to dismiss it. I'll allow time for comments completely, so you can provide any further written comments for the Ombudsman to consider. If you want them to review this phone call, absolutely, I can get them to review this phone call as part of the comments, and we'll go from there. I mean, I can send you my manager's. Do you want my manager's contact details?
Well, I mean, the thing is, just all right. So just because we're finishing off now, it's just my policy not to write things down, to speak to people on the telephone. Hence why I've been speaking to yourself on the telephone. So going forward, if I disagree with yourself, I don't want to do it in writing. I want to speak to somebody regarding my disagreement, and to have the matter escalated back to the Ombudsman. Could you advise me whom I should speak to? Would it be your manager that I need to highlight this to?
Yes, correct. You need to contact a manager, but I can send you his contact details after this phone call.
Okay, so what I'll be doing after this call, because you've made me, because you do understand that, I think we've highlighted this before as well, as a civilian, as a private citizen, I am not required to write things down, and this is normally in a disagreement I have with many professional organizations, is that why should I have to write things down. There's no expectation upon me to write things down. Just for your reference purposes, I do suffer from dyslexia, so even though I can write things down, it does cause me a lot of like unnecessary anxiety that I don't need to do, and I would always prefer to speak to somebody. So just so you can highlight that, and have I made you aware of this in the past?
I don't believe you have, Mrs. Sian, but I can absolutely note it on
Yes.
your account completely. And if things, you've mentioned about sort of, if it's easier, rather than me send this letter to you in writing, we can also send it via an audio recording if that's easier for you.
Well, I mean, the thing is, because you've taken the time to explain it to me on the telephone, I don't think it would add any I would add any value to put it in an audio recording. I'm happy for you to write it down because I can't read. It's not a problem. I can't read or write. It's just that I have like difficulties that I think I would like a preference. I would like to speak to somebody. Like you can understand that it's more natural more natural to speak to somebody than read things and write things. Now, obviously, given my particular position and circumstance, I do obviously write things down, as you can see from the evidence I've submitted. But hence why I've also recorded all my calls with the solicitors. And did I mention to you that I was also recording these calls?
Yes, you've mentioned
Yes, and so
that a few times.
yeah, I mentioned that a few times, and the reason I've done that is nothing to hide or anything. It's simply because that why would I not record them? Because obviously it allows me to reflect upon those things, and I'd rather deal things in an audio manner. So, so I don't think I'm doing anything malevolent there. I'm not trying to hide things from yourself. I've been very clear about and candid about this, and so obviously my evidence would have been in audio format, which is a means that I have, and obviously I usually do that by providing it through like a YouTube link or something like this. But moving on from this, like you've been very courteous to explain to me this your decision and the reasons for your decision. I would like you to write them back to me and advise me with your manager's details, and I would then obviously look to speak to them, all right, upon this, and have the matter like investigated or sent to an ombudsman to bring this investigation to a close, and that will be a decision made by the ombudsman. And then obviously obviously I would like the ombudsman to equally review this call, because I believe that given my objective understanding of your job, I'm a very intelligent person, even though I may have dyslexia, and given what information I've provided with yourself, and the approach and manner I've taken in discussing this with yourself and seeking the clarity of information and guidance from yourself of how you operate, I do not believe that any reasonable person in your position would be justified in looking to bring down this case. And I believe that the decision has been made higher up, and you've simply been tasked to do this. But obviously the grounds that you're providing, I would obviously counter those grounds when I speak to your manager or somebody else. But I first of all need to have the grounds written down, and so I can counter them. And also you'll be providing me with the section in in your policies. I think it was section 5.7 N, did he say? Yeah. So
Correct, yeah.
So if you can provide me with those details, and I will take a review of them, and I will then look to highlight to your manager why I believe your decision to effectively end this investigation is wrong or prejudicial, and it will then obviously your manager, who will then highlight those my concerns and bring them to the attention of the ombudsman to give a final ruling upon this before the investigation is closed. You've made me aware and highlighted that as the investigator, you do not have the powers to end the investigation. All you can do is make a decision that you believe, after having liaise with myself and investigate the matter, that you believe it's not advisable to continue the investigation, and only a ombudsman, not the chief ombudsman, but one of the 40 ombudsmans, will then have to make that independent decision. Is that all correct?
That's absolutely correct, yeah. And obviously I'll confirm that procedure again in the letter that I send you, but that's all correct. So I'll look to, following this call then, Mrs. Sian, I'll send you my manager's details, and then I'll also, try and get that letter out to you in the next few days, okay?
Okay, so once you get me the letter, I will then look to make arrangements with your manager, and then can I ask, how, just as a time frame, just for my understanding, how long does it take for the ombudsman, like if I speak to your manager, highlight my issues with what your decision, your manager then highlights that to the ombudsman, how long does the decision by the ombudsman take to close down the investigation?
normally take, so like I said, once I issue the letter, we normally allow a couple of weeks for you to review the letter, issue any additional comments or anything that you want the Ombudsman to consider. If you do need longer due for any medical reasons, absolutely let us know. We can arrange that. But once I've received your comments, I'll put it to the Ombudsman. The current wait time for an Ombudsman to pick up any decisions is around 4 to 5 weeks, but I'll keep you updated. That can change depending on availability, etc. I believe that's the current wait time at this time as well, and I'm sure the manager will probably advise you of that as well.
Okay.
And then once, like I said, we're around 4 to 5 weeks roughly the Ombudsman picking the decision up and making the decision, but they will contact you directly regarding the decision.
Okay, that's fair enough.
And then the only time I would be back in touch with you then, Mr. Stain, is if they choose not to dismiss the decision.
Okay.
Then obviously I'll continue the investigation. Okay, but they'll be in contact with you directly.
Okay. Under that unlikely event that they choose not discontinue the investigation, then at that stage, can I ask that there's been a breakdown in our relationship and for somebody else to take over, because I believe that then you've acted with prejudice and I've out to obviously override your rule? Does your policies make provisions for me to obviously state that I don't want to be speaking to yourself again because I believe that you've acted, your decisions have been...
You can. Yeah, I mean, if that's the case, then you can make that request to my manager, who will review your request and decide. So you can absolutely request that from my manager. Yeah.
Okay, all right, that's fair enough. Now, in relation to you've made me aware that the solicitors firm have not responded to the evidence request. They've asked for an extra couple of weeks. Yes. Irrespective of your decision, does your decision impact upon them not providing the evidence now?
Well, my decision, so once I pass this for an Ombudsman, I will not review the evidence until... I won't be reviewing the evidence until a decision's been made.
Yes, I understand. So, but the...
So I will still ask them to provide the evidence.
Yes.
But and also chase them for the evidence, because if they can continue the investigation, then fantastic. We'll just move on with the investigation. If the Ombudsman determines that, then I'll have the evidence in place to continue. So I'll still follow up on that process.
Yes.
I personally, the only stop that will happen is I just won't review that evidence.
Yes, that's fine. That's
a
fine.
decision's been made.
Okay.
Okay.
So
and obviously
sorry.
No, go on. Sorry.
So I was just gonna say that, irrespective, obviously you've made a decision. I've made you aware that I'm looking to appeal that decision. That decision is gonna go to the Ombudsman. Once the Ombudsman makes a final decision to end this investigation, it is understandable that the solicitors by that stage would have provided the evidence to yourself. Yes, irrespective of the Ombudsman's final decision. Yes. The solicitor, basically what I'm trying to establish, Sian, is this: that your decision does not effectively negate the solicitors from providing the evidence request that you've asked for, because obviously in the start of this conversation you've made me aware that irrespective of my evidence or their evidence, your policy is to make that disclosure. I have previously made you aware that irrespective of when this investigation ends, I'll be making a subject access request, and so therefore I'm just trying to determine that what my options are, considering I do believe that this case may have been a whitewash. That irrespective of your decision today, irrespective of the Ombudsman's final decision to effectively close down this investigation, there's nothing that there would not be a scenario or a situation where the solicitors effectively get out of what is called a get out of jail free card for them not to provide the evidence. That's correct, yes? So they, irrespective of your decision today, they still have to comply to that evidence request, because the decision by the Ombudsman will be made much later than today.
Yeah, correct, exactly. And obviously, if they've got any further issues, I'm sure they'll advise me. But yeah, absolutely, that's been discussed and established. The only thing that's going to affect the case now is that I'm just not going to review any evidence until it's... That's the only effect that's going to be had on the case, and that's where the delay will come in. Okay. But once the decision's been made, like I said, we should have the evidence in, and we should be able to proceed if the Ombudsman decides that.
Yeah,
and again, it's still
Yes.
to submit it to the MP3 format,
Yes,
etc.
I understand this. I understand this. So, because just to like finish off now, I'm just gonna say because I at this stage suspect malevolence because of the decision that's been made. So I would like to now make a subject access request for the disclosure of the case file up to now. Similarly, like I had made a subject access request in July of 2021 to the solicitors firm because I suspected fraud and foul play. So I would like to make that request now. Would that be possible over the phone?
So you want me to? I can put in a subject access request for you, Mr. Sian. Yeah.
Yeah. So
But for the entirety of the file.
yeah, it's on the entirety of the file and I call recordings with yourself. All right, that would then because I'm working on the assumption that this is a whitewashing exercise and the ombudsman is going to refuse to continue with this investigation. I don't want to wait until the ombudsman's decision because obviously, as I've been quite open and candid with yourself, I suspect foul play at this stage by the ombudsman's office, including the decision that you've made, and so I don't want to be waiting. Like for example, you put me something in writing by the end of like today or tomorrow and early next week. I then speak to your manager. Then the matter gets highlighted to the ombudsman for another 4 weeks, and then I'm waiting. And then subsequently, once the ombudsman refuses to this investigation, as I anticipate to be, as it's a whitewash, so then put in the SAR request in. I'd rather put it in now. So once the and with the caveat that I would like disclosure to be to be held until the ombudsman's final decision. Is that okay?
So just further, so you want me to put the subject access request in, but you don't want any of the information until the ombudsman's made the decision, because they do have a 30-day turnaround on subject access request. So again, you might be better making this request close to the time if you don't want information until the ombudsman's made that request.
No, actually, Sian, what I'll do is I'll make a subject access request for all the information up until now. Okay, and then I'll just to make you aware that I'll make a second subject access request from now until the ombudsman makes a decision after the ombudsman's made a decision. So I don't want to be I don't want to be coming across as a, I think there's a terminology called vexatious requester. I'm not trying to be a vexatious requester. I'm simply trying to navigate this situation. And at this moment in time, I would like to make a disclosure request for everything, so that at least I'll have something in 30 days time, and then subsequently from this date onwards, which is the 11th of May. So by the 11th of June, I should have everything up to now. And then subsequently, when the ombudsman makes his final decision, I will then make a second SAR request starting from today's date until the decision, and hopefully that will definitely have the solicitor's evidence request within that SAR request. Is that correct?
So just to confirm, you want me to make a subject access request on your behalf for anything, including calls, emails, etc., on your file, any information pertaining to you, basically, up to this date. So just to clarify, you want me to put the subject access request in for you?
Yes, and it's the subject access. The subject access request is for metadata, so that should be full, complete, and comprehensive information that's been held by yourself as a result of me contacting you. So yes, that includes any notes or any call recordings or full complete. I mean, usually, like I said, I made you aware. I usually make SAR requests for full, complete, and comprehensive information. I usually make a SAR request at the end of the case, but because you've made this decision today, as a result of that, I'm making a SAR request intermittently or preemptively, simply because obviously I think there's. I feel the relationship has broken down because the decision that you've made is adversely affecting me. So similarly, I made the similar SAR request with the Burke Niazi solicitors in July when I felt that there's something untoward happening. So yes, I would like to make that request today and hopefully receive an acknowledgement from your SAR data protection team confirming that I will be complied within 30 days.
Yeah, well, I'll do that following this call then, Mr. Singh. I'll send you my manager's details. I'll make the subject access request, with what you've just advised me, and I'll confirm that that's been made, and then they will be in touch with you directly, the data protection team. Okay.
Okay, that's fine.
In regarding that request. But I can put that forward. Absolutely, I'll pass that through to them. I'll confirm that I've done that, and then they will be in touch with you.
Yeah, and
Okay.
can you just confirm that it's for full, complete, and comprehensive metadata? So that should be like all the information relating to myself that you hold. So I think you understand that. So if you can just relay that sentiments to them, that I don't want it to be restricted in any manner. And hopefully they'll get back to me, and I will take the matter directly with them. And subsequently, I don't think we'll be speaking again until. Well, I hope we don't speak again then, because irrespective of the Ombudsman's final decision, obviously it would be something that I would not want to like engage with yourself on. So I don't think we need to speak again, do we?
Well, it's completely up to you, Mr. Six. Even while the Ombudsman's waiting to make the decision, maybe you'll have some further comments following my letter, or, if you prefer to discuss that, Amanda, that's absolutely fine. But if you do, I will still be the investigator on the case until it's assigned to an ombudsman.
Yes.
And it may be that the case comes back to me after that. So, if you've got any questions or
Yes.
anything like that you want to discuss, by all means you can contact me. I'll keep you up to date in regards to my letter, submitting it to the ombudsman. If the data protection team come back with anything, but I imagine they'll deal with you directly on that.
I mean, I don't need to speak to you on the telephone again. I'm just envisioning that. I don't think I need to speak to you on the telephone. You can write to me, and obviously, I would like you to still continue to pursue the, Burgundy as his solicitors for the evidence request, because irrespective of my decision to provide evidence or not, they're still obliged to provide. Can you understand that? I feel the fact that this is just simply another gateway to them not providing any evidence, because at this moment in time I have absolutely nothing from them. So not only have I not got the case file, the evidence request that you've made from them, I don't want to find myself in a situation where I would not even have access to that, because I then feel that is quite clearly detrimental and strategic on the part of the decision maker who's made this decision, because they should be open and transparent. I've spent a lot of time obviously bringing this to yourself, and for me to find myself in a situation where the ombudsman is closing this case down and I get absolutely no evidence from the solicitor's firm places me in a very precarious situation. So I think I think the only thing I would say is that you've informed me that they need to comply by the 25th of May, did you say? So if you can just confirm to me, you don't need to give me the information, but just confirm to me that they have fully complied with your request for evidence from them by the 25th of May, and I can do that by email with yourself. Yes? Hello?
Hello, sorry, I think the signal keeps skipping out there, Mr. Say. Yeah, that's absolutely fine. I'll keep in touch with you by email if that's how you prefer. And I'll, I think the data team will be in touch with you directly, but I'll send you confirmation I've made the request for you. And if they, come back to me for whatever reason, which I don't think they will, I think they'll deal with you directly.
Yes.
I'll let you know. But if you do want to get in touch, if you do want to arrange a call, it might be that you have further comments to make or whatever, and you prefer to give them, over the phone. I know you've mentioned you prefer to speak to the manager, that's absolutely fine, but if you do want to speak with me, we can always arrange another time to speak, so...
Okay,
yeah.
Thank you for that, Sian. And like I said, I'm just trying to envision where that circumstance would be necessary. I don't think it would be necessary, but I'm grateful for the...
it might not be necessary,
yeah.
to say.
I'm grateful...
I just wanted to let you know that, if you want to,
yes.
that's what you're for.
I'm grateful for the option to call you again, but I really don't think it would be necessary. But I could be wrong, depending. I don't know what the future holds, so it may be necessary. But I'm grateful for you to, obviously, I feel the fact that, thank you for that, because obviously you don't feel alienated by me or my personality or the way I've spoken to you, because you're offering me to speak to again to me should I want to do so. I personally I can't envision why I would want to speak to you in the future, because I'm going to be speaking to your manager regarding the decision that you've made. And should the ombudsman, on the off chance, uphold my complaint and the matter to be further investigated, then obviously I'll be making a request to your manager to be assigned to a different investigator. And just from my personal perspective, I don't hold you personally. It's not something I've got issue with you against. I think you've talked to me and spoken to me in a very eloquent and respectful manner. I don't have anything personal against you, but just because the fact that you've made this decision, it is obviously I feel the relationship effectively cannot continue, or because it's a relationship effectively of trust, isn't it? And even though I feel the whole process is staged against me, can you understand? It's nothing personal if I make a request to go with a different investigator, because obviously I just feel that it would just be an elephant in the room, I think, if we are to continue to this investigation upon. Yeah. Yeah.
I can appreciate comments as well, and you can absolutely make that request to my manager.
Yeah.
Should the case continue, and if it does, you can absolutely make that request, not a problem. But listen, I'll notify now, so the actions I'll do now is I'll follow up after this call. I'll make the subject access request, and I'll send you an email with, again, my manager's contact details on confirmation that the request has been made for you, okay?
And when are you hoping to get me the decision in writing so I can have a proper read of it and cross-reference it?
Yes, of course. I will. Yeah, I mean, I'll try and get it to you tomorrow, Mr. Stone. It might be early next week, but I'll try and get it to you as soon as possible. Obviously, as you can appreciate, it's comprehensive. But I'll try and get it to you tomorrow. It might be early next week, though. Okay.
Okay. And will your manager be in a position to speak to me next week?
I imagine so. Yeah, absolutely.
Okay.
I mean, I'll inform him that obviously I'll let him know that you've got some dissatisfaction issues and that you would like to speak to him directly. So it might be that he contacts first, but I'm sure you'll
Yes.
contact him
Okay.
first. But I'll make him aware that I've shared his email
Yes.
address with you and that you'll be in contact in that method. But I imagine so. Yeah, you can communicate with him directly. Yeah.
Yes, and obviously the reason for me to speak to him is obviously I would disagree with the decision that you've made, and I would highlight my grounds for disagreeing based upon your written response to me, which you're going to get me to next week. And then obviously I would ask the manager to escalate my concerns to the Ombudsman, and for a final decision from the Ombudsman. And then should the Ombudsman go in my favor, then obviously I will ask for a different investigator from your manager. But alternatively, if the Ombudsman disagrees with me, then obviously that the matter is brought to a close, and I'll be making a further SAR request upon that final decision. Is that okay? Is that clear? Is that
Yeah, absolutely, Mr. Singh. Yeah.
Yes. Okay. Okay, Sian. Thank you very much then.
Okay. Thanks very much for your time, Mr. Singh. Take care. Thank you.
Goodbye. So as you can see, this is a clear whitewashing exercise. This is a whitewashing exercise by the powerful elites who have said, look, we've given this guy enough time, close this case down. So this is the same scenario and situation I'm fighting with the Information Commissioner's Office. A higher authority has asked the Information Commissioner's Office to close down my complaint with them. A higher authority has also asked the Greater Manchester Police to close down my complaint with them, but more importantly, a higher authority has asked them to close down my complaint with the General Medical Council, all completely without, all completely whitewashed. And can you see the excuse that she used? She used that, there's no reasonable prospect of success. That's the same excuse that the appeal application in my regarding the housing association, the judges used word for word, verbatim, no reasonable prospect of success. How can, and I got her in this manner that she was saying, it's because you've not provided the evidence. You didn't ask for the evidence. And how can you make a decision upon no reasonable prospect of success when you've not reviewed the evidence? So they have they've been preemptive in or premature in the decision that she's made. This decision she should have made when after the investigation, but because I've provided them with all the evidence, so they've reviewed the evidence. They're lying to me now, saying I don't have access to the evidence. They've got full access to the evidence. They realize that they're going to have to investigate this, and if they investigate this, my mother's murder would be clearly highlighted through the audio evidence that I've recorded. So one of the things she said that there's no reasonable prospect of success. Thus, a reasonable prospect of success regarding each individual complaint, it should be. All right, this particular complaint does not have no reasonable prospect of success. But she's then reevaluated or metamorphosized it into my whole complaint, my whole case has no reasonable prospect of success. And the reason that my whole case has no reasonable prospect of success at this stage, based on the fact that she's not received any evidence from either party, all right, it's got no reasonable prospect of success, is because it's been shut down by a higher authority, by a higher force. So she cannot make that decision. And the fact that she's stating that she made this decision last week, you can see that, you can review the call last week. I was basically being staged. She was trying to get me to say things, all right, to help her make that decision. Then subsequently, after that email, after my conversations with her, I've sent her clear evidence of a police report from the Greater Manchester Police. They've had a week to discuss this. She was supposed to ring me up yesterday. She's got an extra day. They basically, the public guardian, the legal ombudsman, Paul McFadden, has contacted the chief executive of Greater Manchester Police. They've had cross meetings and cross references, and they've decided now close this case down. We do not want this complaint to go any further, and so they've deliberately closed it down from going any further. And so now we just need to go through this, administrative process of me complaining against the decision made by the Sian, Jeffries. Then the manager that's going to go to the ombudsman. The ombudsman is going to say, I disagree with you, Mr. Sian. I fully agree with Sian Jeffries, who's my employee, who effectively we've instructed to make this decision. We agree with her. We don't agree with you. Close this case down. So this is just simply a whitewashing exercise. You can see that that's why I was trying to get her to tell me what has contributed to you making these decisions. And she was saying, look, I'll write it all down for you. I was saying, no, I'm on the telephone. Tell me those decisions. So there was only two grounds, procedural grounds. One is that there's no reasonable prospect of success, so close it down. That reasonable prospect of success, close it down situation cannot happen because you've not even got the evidence. All right. And the second was that there are other mitigating reasons. And the other mitigating reasons were what I was expressing my opinion. I was providing her with a wider context. You see, the ombudsman does not want to take on this case because obviously they know that Mr. Hussain is utilizing this as a vehicle to have his mother's murder investigated by the police. And we cannot allow that. That's why this case has been closed down, because they know the fact that if they investigate all the call recordings with the Burke Niazi solicitors, they are then obliged to then escalate this matter to the police that, look, we've investigated this and we believe that there's ample evidence available to suggest that his mother was murdered but at the hands of the senior judiciary, and we now need to obviously have this matter independently investigated by the police. So they realize that given the evidence that I've presented to them, all the evidence, and the fact that I've recorded the solicitors, and the solicitors are not providing any evidence of this fact, that they're just trying to end the case before it even starts. And that's exactly what they've done with the Information Commissioner's Office. They've ended my complaint with them, whitewashed it all, even though it's a SAR request, and my request for my data is absolute. Under the Data Protection Act, subject access requests are absolute. They're not under any discretionary reason why they should not give them to me. So the Information Commissioner's Office are now fully embroiled in my mother's murder, and all I'm trying to show is that so is the legal ombudsman, themselves, the office. They're all embroiled because they're all covering each other's backs. And my mother's been murdered. They know it, I know it, and now everybody's trying to hide this fact. So yes, Sian Jeffries was instructed by her managers and her superiors to close this case down and say that it's your decision. It's not her decision, because objectively speaking, if somebody can review all my interactions with her, they will see the fact that I've provided with no reasonable grounds for her to end this investigation. I've been open and transparent and providing her with the fact that my mother's been murdered, and the solicitor's firm played a pivotal role in this. Last conversation that we had, which was on the 4th of May, she was quite clearly acting obtuse, or she was acting, I suspected something then in the questioning that she was asking me, like, Mr. Hussain, what exactly do you expect out of this case, out of this complaint? obviously you've told me what I expect up to uphold my complaints. All right. And then she was saying, well, you can't pursue this through other means or whatever. What's that got to do with you? So they've had a meeting. She's been involved in those meetings, and she was asked, effectively set me up last week. All right. She set me up. I was open and transparent. And I said, no, I just want you to uphold the complaints. All right. And I know the maximum penalty that you can charge is £50,000 under extreme circumstances, but that £50,000 is not enough, and I made her aware of how much I do charge. Subsequently, I've made presented the evidence via email to both her and the legal ombudsman, and so then within a week later, they're quickly closing this down now, and by them quickly closing it down, they're acting prematurely and preemptively, and therefore that highlights their own mens rea or underlying guilt. They have colluded and conspired with other parties right now. It is unreasonable, unacceptable, and unexcusable that Paul McFadden would not have contacted unofficially other people, or even officially other people, considering that I sent him my complaint to considering I sent him and the Sian Jeffries my complaints to the local authority, all the councillors, all the including Kirsten England, and included the Prime Minister, the several members of Parliament. So Paul McFadden has received this. He's reviewed it. He's made the decision to end this investigation, because the reality is that the ombudsman are simply a charade of an organisation just to justify their own financial motives, just like the Information Commissioner's Office and the rest of them. It's just a facade, a charade, a staging that they're doing something, so just to give people red herrings, to give them a runaround. When something like this comes in front of them, basically with evidence, with supporting evidence, an intelligent, articulated person like myself, the only thing that they can do is just shut the case down. So that's what they proceeded to do. They've just decided to shut this case down as quickly as they can, because the reality is that if this case is properly investigated, if this case is properly investigated, it not only creates an existential crisis for the whole of the local authority, but maybe the whole of society, because not only has West Yorkshire Police and Greater Manchester Police and the local authority, but more importantly the judiciary, the independence of the judiciary, particularly Justice Cobb and Justice Cohen, amongst Judge Beckley and Judge Geddes and all the rest of the motley crew, will all be highlighted as committing premeditated murder in order to plunder and profiteer from the deceased's assets. So it's a very, very serious matter that's been brought to the legal ombudsman's attention. They effectively don't want to do anything, and I want to cover this up, and therefore they are simply stating that, this case needs to be closed for these reasons. Those reasons given was simply a desperate last-ditch attempt in order to close down this investigation, and at this moment in time I've made an investment of over 10 hours in order to bring and highlight all the concerns I have. I've recorded all these concerns and I've obviously catalogued them all, but can you see how the matter is now being closed off with? And I fully suspected that this was going to happen, but I suspected that this would occur as a result of finalizing the evidence request. At this moment in time, are you trying to tell me that the solicitor's firm have not complied with the request by the 9th? I don't know if she's telling the truth or lying about this, but basically the solicitors, Burke Niazi solicitors, are connected to the local authority, who are connected to people in powers of privilege and people in power and privilege that can close down an investigation. And effectively this is the only last route to have the matter investigated officially, and even then they're closing this down. They've already previously closed down my complaint with the Information Commissioner's Office. Boom, close that down, so that's not going any further, and now they've closed it down effectively with the legal ombudsman, leaving me in a situation where none of my complaints the murder of my mother is not going to be investigated by anybody, and it's all going to be just covered up, because ultimately who have been caught out, not only the local authority but particular High Court judges, namely Justice Cobb and Justice Cohen. And Mr. Justice Cobb was the head of the family division, and the family division is known to be malevolent and corrupt and stealing people's children, and so ultimately it highlights something quite very dangerous in society, basically the paedophile rings, and so therefore they need to and my case has got nothing to do with paedophilia or the or this, but it's simply to do with corruption. And you can see that they are so conscious and scared of this matter being fully investigated that they were trying to railroad me into giving them piecemeal information. When I said, look, I disagree with this, I don't even, I may not be, they're trying to put me in a position where, you know, they're not, I provided them with all the evidence. They chose not to look into it, simply because they looked into it, but they just chose to look the other eye, because obviously what it highlights is it will highlight the systemic fraud and corruption committed by everybody. And this is the official solicitor, the public trustee, the official solicitor, the court of protection, all the Her Majesty's Courts and Tribunal Services, particularly Nick Goodwin, who was a public guardian, and now is head of the courts system. It basically highlights the whole of the systemic corruption in order to abuse vulnerable adults under this enterprise. And all the solicitors are involved, such as Ramsden solicitors, such as Swaltalski solicitors, such as the official solicitor, and all the other solicitors involved. The solicitors, and including Burke Niazi solicitors, the solicitors play a lesser role. The far more superior role is played by the courts and tribunal services, but the highest role is played by the seniors, by the judges and the senior justices, in order to have a kleptocratic joint enterprise to murder people and then cover it all up, and then give the family members, such as myself, just a means to run around red herrings. Oh, do you know you can go to the legal ombudsman? Oh, do you know you can go to the Citizens Advice Bureau? Oh, do you know you can go here, there and everywhere? Eventually waste your time, and you'll be so exhausted afterward, running around from pillar to post, that you eventually just move on with your life and forget about it while the matter remains covered up. So all purely fraudulent and corrupt, and I've obviously got them on this. And now, as a result of my conversation last week, which can be reviewed, where I've been polite and courteous and respectful, I've just voiced my opinions, and because of voicing my opinions, they're looking to bring it down, saying you've got no reasonable prospect of succeeding. You've not even made an evidence request, okay? You've not even had the evidence. No, you made the evidence request and you've not even received any evidence. The evidence that you've received from me more than substantiates every single one of my complaints. You've not even bothered to get that one from the other party. You've told me you're going to make the other party aware of the evidence. I don't care if they share them. I simply was trying to highlight, I don't want to share my evidence, just to see what they would do. And you see how they're trying to discourage me from providing that evidence. They got caught, slam dunk. They caught them murdering my mother. All right, they can't get away with it, and now they're desperately looking to close things down and trying to end my complaints. I've spent enough hours highlighting and giving my enough time and resources to them, only for them to say, no, we want more of your time and resources. We want you to do our job for us, to pinpoint these things, because ultimately the fraud happens because they treat us equally, and yet they're asking me for evidence, and I was not required to provide any evidence to them. The solicitor's firm have the evidence. They won't give me that the case file, so we can have an established set of facts. I can pinpoint and help them reach and railroad, or help and guide them to upholding my complaints. However, they want to railroad this matter in order to take it to a position where it ends in a dead end. And that's what ultimately this was all about. They were trying to railroad this aspect of the ombudsman into a dead end. So I can't take it any further. And ultimately they achieved what they wanted to achieve: murdered my mother, stolen everything from us as a family, and now they want to leave me in a dead end situation, and that I'm left run around in circles, going dizzy, trying to solve the situation, which is ultimately designed to, which is ultimately designed for me to fail. Absolute horrendous. What a joke. What a waste of my time and resources. They're such liars and crooks.